Good morning, everyone. I'm Dana Ladner with the Kansas Department of Agriculture, and I want to welcome you to our final webinar as part of the Growing Strong Together series on workforce-related topics in agriculture. And with that, I'm going to turn it over to Wendy. Morning, Wendy.
Good morning, Dana, and thank you. Good morning, everyone. My name is Wendy Mojo. I serve as the State Monitor Advocate for the Kansas Department of Commerce. And in my role, I support and advocate for strong services for our agricultural employers. I appreciate you taking time today for this webinar focused on wage and hour compliance under the H-2A program. This topic is important to ag employers, and this morning our speaker will provide practical guidance on wage obligations, regulatory requirements, and enforcement. As we know, staying informed is critical to reducing risk and maintaining compliance in an evolving regulatory environment. Now, before we get started, a few housekeeping items. First, all participant microphones will be muted during this presentation. Second, if you have a question, please submit your question using the chat button at the bottom of your screen. We will be monitoring the chat and we'll address questions at the end of the presentation. And lastly, this is being recorded and this will be made available online next week on the KDA website. Now I'd like to introduce Cassie Stoner. Cassie is a wage and hour investigator with 15 years of experience enforcing federal labor laws. She directly works with employers to assess compliance, provide technical assistance, and ensure workers receive the protections guaranteed under the law. Cassie, I will now turn it over to you to share your presentation. Thanks.
All right. Hello. Good morning, everybody. I'm going to go ahead and share my screen. All right. Hopefully everybody can see that. So thank you, Wendy. Again, my name is Cassie Stoner. I am a senior investigator with the U.S. Department of Labor Wage and Hour Division in the Kansas City District Office. So my agency, the Wage and Hour Division, enforces the H-2A program along with the Fair Labor Standards Act. And that's a law that sets minimum wage, overtime, and child labor provisions. We also enforce various other laws, all regarding payment of wages. For this presentation, we're really going to focus on H-2A and requirements that matter most for you guys. So wages, recruitment, housing, transportation, and record keeping. H-2A is a very robust program that we're covering in a very short period of time. So if you have questions, please drop those in the chat. We'll try to get to those. But if you have follow-up questions, I'm going to include in the chat my direct phone number. So please don't hesitate to reach out. You can also call our technical assistance line, and that will get you to the nearest office. All right, and just as a general disclaimer, this is general information only. Everything regarding H-2A program can be found in the Code of Federal Regulations. That's basically the law itself for H-2A. So the Immigration and Nationality Act, or the INA, authorizes admission of temporary non-immigrant workers to perform agricultural services that are temporary or seasonal. And so that's what we'll be talking about. So H-2A, the law is administered really by two agencies under the U.S. Department of Labor umbrella. So the first is going to be the Employment and Training Administration, or ETA. They're another agency, and they're going to handle the certification process. So that's who you apply to, and that's who certifies you to participate in the H-2A program. So they kind of handle everything before the workers arrive. Wage and Hour, my agency, we kind of handle everything after. So we're the enforcement of that certification or that contract. So we look at the work contract, which is going to include your wages, housing, transportation, as well as U.S. worker protections. All right. Now there's types of workers under the H-2A program. The first and easiest to recognize are going to be your H-2A workers themselves. But what a lot of employers miss is that non-H-2A workers can actually fall within the scope of the H-2A program, and they are what we call a corresponding worker. There are two ways in which a worker can be corresponding. The first is if they're performing the work that you have listed in your job order or your job certification. So for example, if you are certified for ag equipment operators to be operating a combine and cutting in the field, you have non-H-2A workers performing that work, they are still subject to the same terms and conditions as your H-2A. The second way a worker could be corresponding is simply if they're performing the same work as your H-2A worker. So maybe that work's not listed in the job order, but if you have your H-2A workers performing that work, any other workers would be considered corresponding, and they're just subject to the same terms and conditions. Right? So these are the employer obligations, things that we'll be talking about, right? U.S. worker recruitment, disclosure, our wage requirements, housing, transportation, meals, preferential treatment, and record keeping. So U.S. worker recruitment, this is very important part of the H-2A program. So before hiring an H-2A worker, you must do a couple things. So one is going to be if you have any U.S. workers who worked for you in the prior year, you must offer them return to work. So reach out to them if they are able to return to work, if they want to accept that job, you must reach out to those former workers. Any workers who has applied, whether that's a direct applicant or a referral from the state workforce agency, you must keep a record of whether they were hired. If they were not hired, the lawful job-related reason that they were not. And if you have any U.S. worker who applies, if they are qualified during the recruitment period, they must be hired. Your recruitment period is going to be up to 50% of your contract. So if you have a 6-month contract, months 1, 2, and 3 are going to be your recruitment period. You are only able to turn away U.S. applicants for a lawful job-related reason. So maybe they don't meet the minimum qualifications. Disclosure of the work contract. So work contracts must be provided. I will say from experience, we very rarely see a separate employer-created work contract. Most of the time, it's going to be your job order that was certified by ETA that will stand in place of the contract. For an H-2A worker, that should be given to them before they leave their home country. If you have a corresponding worker, a U.S. worker, that should be provided to them on their first day of employment. Or if you have somebody who maybe works for you year-round or has worked for you for a couple months, a copy of that job order or work contract should be provided on the first date of their contract period. This is a very common violation that we see for corresponding workers. So even if you've had somebody who's worked for you for 10 years, if they're corresponding, so doing that work in the job order, every new contract period, make sure they get a copy of that job order or that contract on that first day. All right, wage requirements. This is the big one with H-2A. So the employer must pay the higher of the applicable, and you'll see all these things on the screen. From experience here in Kansas, the biggest one is going to be the adverse effect wage rate, or the AWER. That is typically the highest rate that we see, but if you have one of these other, either a higher hourly rate, wage or a federal or state minimum wage, then that would be the rate you pay. So you must pay the AWER rate. Employees must be paid no less often than semi-monthly, which means monthly payment is not allowed under the H-2A program. And any deductions have to be either required by law or disclosed as part of your job order and certified as allowed by ETA. So there are some new changes when it comes to the AWER in 2026. There is an interim final rule in place, and this is going to be for new certifications after October 2nd of last year. So if you have a current certification that was certified prior to October 2nd, all the terms and conditions in that are still going to apply. But for any new certifications after October 2nd, it might look slightly different. So first, there's kind of a change in the methodology and the way that the rates or that AWER is calculated. And this final rule also created a skill-based tier system where you'll see workers broken out into a tier 1 or a tier 2 category. So I talked a little bit about ETA there, that certifying agency before wage and hour steps in. ETA is going to be who certifies what skill level employees fall within. It's estimated about 90% will fall within skill 1, but we may see some skill 2 jobs, such as our ag equipment operators operating a combine. But keep in mind that determination is made by Employment and Training Administration. What is important for you to know when filling out that application is to make sure that you are accurately reporting the work to be performed. As wage and hour, that's what we want to see, that the workers are accurately performing the work that you have stated in your job contract. That way we know that ETA had the information to certify the correct rate of pay. So for field and livestock work here in Kansas, a skill 1 rate would be $12.69 per hour. A skill 2 rate is $18.14 an hour. One thing that we also see very frequently in Kansas are heavy tractor and trailer operators. Keep in mind, if they're spending more than 50% of their contract days performing that work, ETA may certify them at a higher rate, so just be mindful of that. If you have questions on how it's determined what skill level they're at, I would encourage you to contact ETA as they're doing that certification. And finally, with this final rule, there is what is called an adverse compensation adjustment, or really a housing adjustment. So this is new. H-2A workers that receive employer-provided housing free of charge, the employer can make a reduction in their hourly rate of pay. In Kansas for 2026, that is $1.26 that you could reduce from their base rate. Again, 2 criteria have to be met. 1 is for H-2A workers only, and 2, that the housing must be provided by the employer free of cost. So for example, if you have an H-2A employee that maybe is living with friends or a partner, you would not be allowed to take that deduction. All right. Wage requirements, I'd like to point this out briefly because this is a common issue we see, again, with corresponding workers. If somebody is paid a method other than hourly, each pay period, we want to see their pay broken down to the hourly equivalent to ensure that they're meeting that AWR. So for example, where we see common issues are with salaried employees. So if an employee is paid a salary, a record of hours still should be maintained. We want to see the hourly equivalent. And if that pay period is less than the AWR, you would need to bring them up to that minimum amount. And that is computed on a pay period basis. So it can't, come out in the wash at the end of the contract season or average multiple pay periods together. So I always just like to point that out. It is a common violation that we do see. 3/4 guarantee. The employer must guarantee to offer at least 3/4 of the total hours promised in the work contract. So if you have a contract that has a total of 1,000 hours, employees should work or be offered 750 hours. This is determined on a contract basis. It is not per week. It is not per pay period. So we look at the end of the contract period. There are a couple things that can stop the 3/4 guarantee. One is if the employee voluntarily leaves and proper notification is made to ETA. 2 is if the employee is terminated for cause and proper notification is made to ETA. Or 3, if there's an act of God that causes contract impossibility, and that must be certified by ETA. So if you have questions on that or you have a scenario that rises up, please feel free to reach out to myself or to your local office, and we can help you with that process if you have any questions. Housing requirements. Employers are required to provide housing at no charge to the employee. Should be certified by the state workforce agency before employees stay in that housing. And that housing should meet basic occupancy, safety, and health standards. If during your contract period, an employee comes to you and maybe there's been damage to a window or some electrical damage, make sure you're taking that seriously and looking at that and rectifying any issues that may arise. Meals, an employer must provide meals or cooking facilities, so a kitchen with some basic kitchen utensils. If meals are provided to H-2A, you also have to provide those to corresponding workers. And if you disclose it in your job order, you can provide meals and then charge the ETA approved amount for meals. That changes every year. Currently, it is $16.28 per day. If you have workers that are traveling, they still must have access to a kitchen. So if they are staying in a hotel that maybe only has a microwave, at that point, you would either need to provide meals to them or provide reimbursement for meals of $16.28 per day minimum, up to $68 per day if that employee provides receipts. If they're staying in a bunkhouse that has full access to a kitchen, they've got a stove, oven, refrigerator, and it's adequate for the number of employees, then that would meet that meals requirement. Transportation, this is going to be our inbound and outbound transportation. I kind of lumped them on one slide. The employer is required to pay the cost for transportation based on the most economical form of transportation available. So if you have a worker that could spend $100 on a bus ticket, they choose to have a $400 airfare, you're responsible for the $100 bus ticket, right? Transportation does begin at the place of recruitment. So when we're thinking about inbound and outbound transportation, we want to expand. It's not just what's the cost of the bus ticket or what is the cost of the airfare. Is there a cost for the employee to get from their home to the bus stop or to the airport, and what is that cost? Meals, the employee has to spend money on meals to travel, so that rate is $16.28 per day. Does the employee live away from the airport or bus station where they might have to travel the day before and stay overnight in a hotel? So those are costs that are frequently missed that are part of this transportation requirement. You can advance transportation and subsistence costs to the employees. Some employers choose to just pay it all up front. Some choose to pay it up front and then deduct. You can do that as long as, one, you are certifying so in your application to ETA that you will be making that deduction, and two, the Fair Labor Standards Act does still apply. So employees should still be receiving at least $7.25 per hour for each hour worked. If an employee is paying for their transportation or you're deducting that transportation, it should be reimbursed, the inbound transportation, at 50% of the job contract, and your outbound transportation once the contract is completed. Transportation safety. So once workers are here, transportation should be provided from their home to the job site at no cost. And all transportation should comply with local laws. So seatbelt laws, DOT regulations, speed limits, all of that's going to apply. No preferential treatment. We talked earlier about corresponding employment. I really want to stress that concept of corresponding employment. For any U.S. workers, they have to be receiving the same benefits, wages, and working conditions offered to H-2A workers. So if you are paying your H-2A workers $19 per hour, U.S. workers in corresponding employment must be paid at least $19 per hour or higher. The job offer can't impose restrictions or obligations that are not imposed on H-2A workers. So for example, if you are turning away a U.S. worker for failure to have a CDL, however, your H-2A workers are not required to have a CDL, that could potentially be a violation. And again, any U.S. worker who is qualified up to 50% of that contract period must be hired, only turned away for lawful job-related reasons. Deductions. So anything that the employee needs to perform their work should be provided by the employer. No deductions are allowed to be made for that. If you have any deductions from pay, it should be stated so in your certification. And also state workers' comp must be provided at no cost. And if a worker is injured, then you must provide them that workers' comp policy. That way they can make a claim. That is something that we're seeing more and more pop up, that employees have been injured and the employer is declining or refusing to provide that workers' comp information. Fees. Any fees related to obtaining the visa must be paid by the employer. That's going to include any attorney fees, application fees, visa fees. And also when we're thinking of visa fees, it's not just the visa itself, similar to when we talked about transportation. If there's cost for that worker to get to the consulate or the embassy to get that visa, that should be paid. If there are any mailing fees, that should be considered and paid as well. So really any costs associated with getting here are paid by the employer. The only exception is the passport. The employee is responsible for the cost of their passport. Compliance with other laws, this is pretty straightforward. H-2A requires that you're also in compliance with any other federal laws. So we talked about the FLSA, but any state or local laws. Also the prohibition against holding a worker's passport or their immigration documents. Record keeping. So if we are to do an investigation, right, we're going to look at records. And this is the biggest thing I want to stress, is that it can seem daunting, but record keeping is going to really help protect you. And it is going to make things easier in the end. So for record keeping, these are the things that are required under the H-2A program. One are field tally records. I don't see much piece rate in Kansas, but if you have any type of piece rate or anything where there'll be field tally, you must keep that. The number of hours offered or worked in each day, the beginning and ending times of each workday. So do they start at 7 a.m. and do they end at 5 p.m.? I also think a good practice is to record the start and end times of any lunch breaks where they are completely relieved of duty, the rate of pay, the earnings per pay period, the home address. I also encourage to get a phone number as well as an email address, but the home address is what is required, along with any deductions from pay and what those deductions were made for. So these are records that the employer is required to maintain and have available, and keep those for 3 years. Pay statements. Pay statements or a check stub must be provided to each worker no later than each payday. So some of the common things that we hear are that, well, it's direct deposit. They could go to the bank, or we don't give a check stub. Check stubs or a pay statement is required to be given. And there are certain things that must be included on that pay statement. So a worker should be able to see, one, their total earnings. What did they earn in that pay period? What is their hourly rate of pay? So how much are they paid per hour? How many hours were worked? So really, they worked 80 hours at $20 an hour, and here's their total pay. If there are any deductions and an itemization of what those deductions are, the beginning and end dates of the pay period. So you can imagine if you have a stack of check stubs, you want to be able to see what pay period does this check stub cover. And lastly, and this is the one that is missed the most, so I really want to stress this, the employer's name, address, and the federal ID number. So the federal ID number is frequently missing on the check stubs. I always want to stress that. Make sure you have all of that included on the check stub, and it is given to the employee on each and every payday. Not only your H-2A workers, but also those corresponding workers that we've talked about. This is our beautiful green H-2A Notice of Workers' Rights poster. We have these in English. I do believe that they are also in Spanish on the DOL website, but this should be posted somewhere that a worker would see it. So a workshop, somewhere that a worker is entering routinely. I usually see them in a comment area, but a lot of the time employers also put them up in the individual houses. That's great. It should be up in a language that is common to a significant portion of the workers. So if you have Spanish speaking workers, please make sure you have this up in Spanish. If you have another language and aren't able to find that poster, please reach out to us and we will do our best to get you that poster in that language. And information on the application process, that is going to be done through ETA, or the Employment and Training Administration. So they're helpful on who can apply, where to apply, how to apply. We talked about that final rule that has that skills-based testing, and is somebody considered field and livestock, or they considered heavy tractor trailer, ETA is the one who is going to make that certification. And wage and hour, we will enforce that rate that ETA is certified, as long as what the work that you provided to ETA is actually what's being performed. And then compliance assistance. This information can be found on our website. You have the actual Immigration and Nationality Act. You have our different regulations, so the Code of Federal Regulations. If you're wanting something that is not so text and regulatory heavy just to read, I always recommend the fact sheet. So we have fact sheet 26, and then we have some different worker rights information. And with that, if you have any other questions, you can visit our website. We have a lot of compliance assistance on our website. You can also call at 866-4US-WAGE. That's our technical assistance line. It will route you to your local office or the next local office. We want to try to get you to a live person, but I've also dropped my direct number in the chat, so you can feel free to reach out to me. And with that, that is the end of our presentation. So if there are any questions, I'd like to take this time to answer any of those.
Hi, Cassie. Thank you so much for that very helpful information. No questions in chat. I have been checking, but I do have a question myself. So out of all the requirements that you listed, which ones do you see employers struggling with the most and why?
Mm-hmm. So there's two issues that I look at, and these are two issues that kind of have a tendency to snowball. So the first is going to be record keeping. I cannot stress enough the importance of good record keeping with this program. So again, it seems daunting, but H-2A is very technical. So keeping record of time records, keeping those in a location where you can find them easily if you need to refer back to them, pay statement requirements. If you have U.S. workers, keeping documentation of did you hire them? If they were not hired, what is the reason why? So record keeping, I'm really, really stress. The other is going to be that concept of corresponding employment. Workers tend to really miss that. They think, or employers tend to miss that. They think that H-2A applies to my H-2A visa holders only, but it also applies to your U.S. workers. Or maybe you have workers on a J-1 or a green card or a different type of visa. If they are performing work in the application or the same work as that H-2A, they're subject to those same terms and conditions. So those are the two things that we do see issues with that I think are really easy to correct, that employers just need to be made aware of.
So what's a common misunderstanding you see when it comes to the H-2A compliance then?
So a lot of the time we have this misunderstanding that the H-2A program like really dictates how you run your farm and how you run your business. I always want to stress that as an employer, you have a lot of decision-making authority and what works best for your business and your establishment and your farm. So H-2A is really setting kind of that minimum threshold of what it is you need to provide. And if you ever have a question, or if any employers out there have a question that I want to do something this way, is it in compliance? That's what Wage and Hour is here for. Our number one goal is compliance. So please reach out to us. But please don't feel like because you're in the H-2A program, you don't have the autonomy to make the decisions that are best for your business.
Okay, cool. I don't have any other questions. Dana, did you have anything to add to this?
I do not. You have done a great job. And Cassie, thank you very much for providing your phone number. That helps out a lot. Like I say, those that are on, make sure you grab that out of the chat. If not, that direct number is 316-361-2713. You can get a hold of Cassie that way, or the technical assistance line is at 1-866-4US-WAGE. So we've got that. I do not see anything else in the chat either, Wendy, Cassie. So I think we'll just wrap this up. So on behalf of the Kansas Agriculture, the Department of Commerce, and the members of the Nurture Kansas Ag Collaborative Coalition, thank you for your time. Participants, thank you very much for your time as well. We hope that you've enjoyed the March webinar series, and we trust that you've had at least one takeaway from each of the presentations. Please look for an email shortly here in the next day or so for a survey on the entire webinar series for feedback, so we can improve this for next year. So with that, thank you guys very much for everything. Thank you for participating, and have a great day.
Thanks.
Thank you.
Bye.
Thanks.